enforcers of law who are tasked with maintaining public order, protecting individuals and property, and preventing and investigating crimes. That is what being a police officer means, or at least that's what they are trying to do. Instances have aroused where police officers have misused their authority, employed excessive force, and violated people's rights, particularly those from marginalized communities, leading to distrust and fear of law enforcement. Are they subjected to such power? What are the legal repercussions for them, however? And most of all, would they be treated differently when compared to the masses? Join us as we take a closer look at two of the most uncanny cases that could make question the judicial system as a whole. Our first case kicks off with the case of Harold Hill, which is just a perfect example of how our justice system can go wrong. This case definitely checks all the boxes, including a horrific rape and murder, as well as a mishandled conviction, you name it. So then what went about? Let's start with the so-called beacons of justice, Kenneth Bordeaux and John Halloran, the detectives who were assigned to the case and the beacons of law. They were the ones who managed to extract a confession from Peter Williams, who was later discovered to have been in custody when the crime was committed. How did they even produce a fabricated confession from someone who wasn't even present? Hill claims he was physically and mentally tortured until he confessed to crimes he didn't commit. Is this the kind of conduct we anticipate from our law enforcement personnel? The trial itself was held when Hill was 31 years old, despite the fact that he was only 16 at the time of the crime and was therefore tried as an adult. At this point, it's just not fair, and it's incomprehensible what Hill is going through. Given that neither of the defendants had a criminal history prior to the incident, this is an intriguing move by the prosecution. Hill and Young were given a life without parole sentence after the jury found them guilty of the murder. However, 13 long years later, DNA tests showed that neither of the defendants' cellular components found under Kathy Morgan's fingernails, nor the hair found at the crime scene matched either of them. Imagine the sheer suffering Hill endured for something he didn't do. It continues to amaze me how Hill managed to hang on to his life. The prosecutors disputed the findings despite this evidence, claiming that the hairs had nothing to do with the crime and that the cellular material might have come from sweat or drool that the recovery teams had left behind. Even in the face of such overwhelming evidence, it's shocking that the prosecutors were so resistant. Young was killed in a hit-and-run incident shortly after Harold and Young were finally let out of jail. This almost leads us to believe that this is almost a plot to clip both of them. Hill, on the other hand, accused the city of Chicago, the police, and the two detectives involved in the case of coercing a confession and violating his civil rights in a complaint he filed against them. The case was resolved for $1.25 million, of which Hill received $500,000 and the remainder was paid to the lawyers. It's surprising that the detectives were only asked to make a pitiful $7,500 payment for their roles in this whole fiasco. You think that's all? Wait until you hear this. It should be noted that Hill is currently serving a 27-year sentence after being found guilty once more of an unrelated charge of armed robbery. In spite of this, it is obvious that Harold Hill was let down by the legal system in the past. This case emphasizes the need for justice system reform to prevent erroneous convictions and make sure that those who abuse their power are held accountable. Starting with the investigation and continuing through the trial and conviction, the Harold Hill case is a tragedy of errors. Hill was wrongfully detained for 13 years, and because the system made him a criminal, he was never given the opportunity to adapt to life outside of prison. He was completely screwed over by the system, and the police only received $7,500 each. When police officers commit acts like the ones they did, they should be imprisoned for a minimum of the same amount of time as the victims they imprisoned. Up next, we have an oddball in the form of Sergeant Mario Cardona versus Daniel Garza. After being thrown and pinned to the ground, Daniel Garza was rendered helpless. Officer Mario Cardona, a longtime friend of Garza's, was on the verge of breaking his wrist. Confronting a criminal and keeping him confined is one thing, but putting a civilian without a reason is shocking. Garza recalled, I was trying to be a man and trying to hold in the pain, but man, that wrist lock hurts. He's just bending it and bending it. But why did Cardona go so far as to nearly break his wrist? His actions were apparently driven by rage toward Garza, whom he accuses of attempting to kidnap his stepdaughter. But are cops subjected to such an authority in the first place? It appears that the two men had a long history together because Garza had once dated Naomi Villanueva, the stepdaughter of Cardona. Villanueva left her parents' home to live with a friend because the relationship had reached its breaking point. However, Villanueva was allegedly taken from her friend's home in May 2015 by Garza without her consent and brought to her parents' residence in Whittier, where Cardona lived across the street. Garza was performing pilates in his garden when Cardona saw him and told him to go to the street. Cardona started his assault as soon as Garza sat down. Garza claimed that he was not the aggressor, and a neighbor who saw the incident attested to Garza's innocence. As soon as they arrived on the scene, the sheriff's deputies saw redness on Garza's face, bruises and abrasions on his knees, and redness on his wrist. After Garza complained about Cardona, the city of Los Angeles, Chief Beck, and Cardona were named as defendants in a federal lawsuit. Garza claimed that he had been the victim of a false arrest, an arbitrary search and seizure, overuse of force, an assault and battery, negligence, and intentional infliction of emotional distress. The trial also featured a video of the incident captured by one of Garza's neighbors. They had made up a story of what had happened to make him look like a hero, and me look like a criminal, Daniel Garza. The hearing was presided over by U.S. District Judge Stephen V. Wilson, who heard former Deputy City Attorney Michael Amarian speak in defense of the city. Cardona was found to have acted maliciously as an off-duty officer by the jury, and on June 26, 2017, he was ordered to pay Garza $210,000 in damages. In addition, the court added $664,000 in attorney's fees and $26,000 in post-trial costs. The city of L.A. refused to take responsibility for Cardona's actions and even refused to indemnify the officer, forcing him to pay for the charges out of his pocket. Jim DeSimone, Garza's attorney, claims, "This is the problem with the LAPD. This is why people are out on the street." The incident serves as an example of how police can abuse people and get away with it. In this instance, however, Garza was able to confront the authorities who had infringed upon his rights and prevail in his lawsuit against Cardona. It is clear that police officers cannot get away with using excessive force against citizens after the jury found Cardona guilty of malice. It is important to note that this case also emphasizes how crucial it is for citizens to be aware of their rights and to speak out against law enforcement when they believe those rights have been violated. Garza's decision to accuse Cardona of using excessive force and file a complaint against him demonstrates that people can take legal action to stop police brutality. What do you think of these cases? Which do you think is most unfair? Sound off in the comments below and make sure to let us know if we missed out on anything. While you are at it, make sure to hit that subscribe and leave a like to never miss an update from us. Thanks for watching.
Ahmed Al-Manhali, a United Arab Emirates citizen, traveled to Avon, Ohio in June 2016 for medical treatment at the Cleveland Clinic. Upon arrival at the Fairland Inn and Suites, he was informed that the hotel was fully booked due to the Republican National Convention. Ahmed politely requested alternative accommodation options. While waiting in the lobby, a SWAT-style response occurred, with Avon officers arriving and detaining Ahmed, who was simply walking out of the hotel while on his phone.
On the ground, no! Get on the ground! Get on the ground! Down! On the ground, do it now!
Get on your car.
Down! Hold on!
Confused by the situation, Ahmed questioned the officers, but they handcuffed and searched him, damaging his phone in the process. They found a second phone, which Ahmed used for business purposes.
What happened? Take the phone away! Cover the entrance, help me get back.
What is it?
Go down there.
What happened?
Despite no evidence of wrongdoing, the officers treated Ahmed as a terrorist, disregarding any investigation or backstory. Simultaneously, an officer spoke to the hotel receptionist who had made a 911 call, falsely claiming Ahmed had pledged allegiance to ISIS. The officer soon realized it was a false alarm and called off the search. Meanwhile, Ahmed collapsed and passed out, prompting paramedics to administer aid and to take him to a nearby hospital. The incident gained international attention, leading to the United Arab Emirates Ministry of Foreign Affairs to demand an apology from Avon officials. The mayor and police chief apologized to Ahmed, emphasizing that the incident did not reflect their community's values. Marriott International, the hotel's owner, expressed regret and committed to training to prevent similar occurrences.
You should not have been put in that situation like you were.
There were some false accusations made against you, and those are regrettable.
Mayor
Jensen said in a statement, "This was a very unfortunate incident and does not reflect our community. Avon is proud to welcome visitors from the United Arab Emirates and other countries who regularly come to Northern Ohio for tourism, business, medical care, or education."
The settlement aimed to compensate Ahmed for physical, psychological, and financial damages. However, he still faced lasting emotional distress, was haunted by the officer's eyes, and experienced sleep disturbances. The incident highlighted the need for improved cultural understanding and sensitivity among law enforcement personnel. Here we have Brian Filipiak, a 47-year-old Washtenaw County Sheriff's Lieutenant, who was off duty when he got pulled over. Deputy Morrison, after stopping Lieutenant Filipiak, informed him about the reason for the traffic stop. Subsequently, Deputy Morrison inquired if Lieutenant Filipiak had consumed any alcoholic beverages that afternoon. In response, Lieutenant Filipiak acknowledged that he had indeed consumed a couple drinks. After Deputy Morrison confirmed Lieutenant Filipiak's identity, he returned to his vehicle and instructed the lieutenant to exit the truck for a field sobriety test. The purpose of the test was to assess whether Lieutenant Filipiak had consumed an excessive amount of alcohol, despite it being evident he was clearly unfit to drive. Exhibiting evident signs of severe intoxication, such as slurred speech and watery eyes, Lieutenant Filipiak left no room for doubt that he was heavily under the influence.
Okay, you got your ID?
However, despite this clear indication, Lieutenant Filipiak adamantly refused to comply with Deputy Morrison's request to step out of the vehicle. Instead, he insisted that Deputy Morrison should either allow him to return home or let him sleep it off on the side of the road. In response, Deputy Morrison firmly informed Lieutenant Filipiak that his options were limited and made it clear that he would not allow him to be released in his current condition.
Multiple reckless driving calls about you. Okay? And then when I'm calling you, you're hitting the shoulder of the road. You been drinking? How many? Okay. What are you reaching in the back for? I seen you reaching in the back. You have an open container back there? Okay, you been drinking on the way here? Got your registration, proof of insurance? Do you have a firearm on you? Okay. Do you got your pistol? Are you a corrections officer or just deputy? Lieutenant? Okay.
Despite Deputy Morrison's persistent attempts to persuade Lieutenant Filipiak to exit the vehicle, the latter remained adamant in his repeated request to be released. He proceeded to assert that Deputy Morrison's job would not be jeopardized if he let the situation slide, emphasizing the potential consequences for himself if the matter were pursued.
Brian, I'm going to have you step out of the car. I'm going to do a field sobriety test for you. Okay?
However, Deputy Morrison understood that ignoring the incident would not only lead to his termination, but also result in misdemeanor charges carrying a penalty of up to 1 year of imprisonment or a fine of $1,000. Deputy Morrison was fully aware of the extent of Lieutenant Filipiak's intoxication, as he had allegedly observed the lieutenant discarding open containers in the back seat during the traffic stop.
I'm going to ask you to step out of the vehicle. What would you like me to do?
Just let me.
I can't. I had multiple phone calls. You'd be in the same situation if I was in the vehicle in your county, correct?
All right, just let me stay here.
You can't. I'm going to ask you nicely to step out of this vehicle. Brian, my hands are tied. If I let you go, I'm going to lose my career over you. You don't think I wouldn't?
No.
This is northern Michigan. We're a small department. Okay, I'm going to ask you nicely to step out of the vehicle. You know I have my job to do. You know that.
Yeah, and I just want you.
And I understand Your point, your position. Okay, I'm trying to be as cooperative and nice to you as I can.
Despite Deputy Morrison's continuous efforts in trying to have Lieutenant Filipiak step out of the vehicle,
after nearly 5 minutes of persistent requests for Lieutenant Filipiak to exit the vehicle,
Just let me go.
I can't let you go. We're way past that point. You know this. You're a lieutenant. You know how this works.
Yeah, I do.
You would tell one of your deputies if they called you right on the side of the road and they asked you what to do. So, if one of your deputies is in the position as I am right now, calling you as a lieutenant, Lieutenant, this is what I got. What should I do? You're just going to say, let him go? Why? Just because. You're intoxicated. I know it. You have open alcohol in the vehicle that you passed back. I know it. You know it. You're a good guy. Ryan, out of this vehicle. I'm asking you nicely. I don't want to see anything worse happen. Okay?
No.
Deputy Morrison, having reached the limits of his patience, opened the door and firmly instructed the lieutenant to step out, avoiding any need for further escalation. Deputy Morrison proceeded to inform Lieutenant Filipiak that he would be arrested for refusal to comply if he persisted in refusing to exit the vehicle. RNO, an abbreviation for resisting and obstructing a police officer, is a felony offense that carries a penalty of up to 2 years of imprisonment, a fine of $2,000, or both. After an additional 5 minutes had passed, Deputy Morrison cautioned Lieutenant Filipiak that he would be tased if he continued to resist compliance with his instructions. Consequently, Deputy Morrison retrieved his taser and aimed it at the lieutenant, while firmly warning him that failure to comply would result in being tased. Deputy Morrison even considered using the backup taser at that moment. In this situation, Deputy Morrison possessed the authority to employ his taser and would not have faced repercussions for doing so. Fortunately, the threat of being tased successfully persuaded Lieutenant Filipiak to finally exit the vehicle. As anticipated, Deputy Morrison did not tolerate Lieutenant Filipiak's resistance, instructed Lieutenant Filipiak to occupy the back seat of his patrol car, intending to transport him to the police station. Despite Deputy Morrison's clear directive to sit in the car, Lieutenant Filipiak persisted in his refusal, stating, "I am who you guys are. Do you guys realize that?" This remark strongly indicated that Lieutenant Filipiak was attempting to exploit his position of authority, seeking a preferential treatment based on his status.
All right, we're done with this.
Hold on.
Talk to me. Yes or no? Are you doing field sobriety tests?
All right. So if this was the other situation,
Lieutenant Filipiak clearly held the belief that he was exempt from abiding by the law. However, the officers present at the scene were determined to make it evident that such was not the case. Following some further struggle, they managed to successfully place Lieutenant Filipiak inside the patrol car.
I'm not resisting, but let's stop.
Let's stop.
Let's talk about it. Okay.
We've talked. I don't want to put you on the ground.
No,
I don't want to make this worse.
All right, I will just sleep it off.
Dude, stop it right now. You know? Stop it.
Allowing for his transportation to the police station where he would face the consequences of his actions. Subsequent breath tests conducted at the police station revealed that Filipiak's blood alcohol level registered at 0.28 and 0.27%. For context, the legal limit for operating a motor vehicle in the United States is a mere 0.08%.
What happens? We're going to take you to the jail and ask for a data master. And if you refuse that, we're going to get a search warrant for your blood. Brian, have a seat.
Stop, guys. Hold on.
Therefore, Lieutenant Filipiak's blood alcohol concentration was over 3 times the legal limit, subjecting him to Michigan State's super drunk law, which carries penalties of up to 180 days in jail, fines of up to $700, and up to 360 hours of community service. So it's time to watch our next case. On July 26, 2021, the Orangeburg Department of Public Safety received a distress call from a female resident of Colton Village Townhomes in Orangeburg, South Carolina. The caller reported that a man was vigorously banging on her door and window, attempting to gain entry. Furthermore, she alleged that the man possessed a firearm tucked into the waistband of his jean shorts. In response, dispatch promptly directed all officers in the vicinity to respond without delay. Officer David Lance Dukes arrived as the first responder at the scene. With his firearm drawn, Officer Dukes exited his patrol car and proceeded to instruct a 58-year-old disabled man, along with his cousin DeMario Julian, to immediately lie on the ground. At this juncture, it was evident from the body camera footage that Mr. Gillard was complying with Officer Duke's commands. The recording captured Mr. Gillard raising his hands in the air and proceeding to lower himself onto his hands and knees as directed by the officer. However, before Mr. Gillard could fully assume the prone position on the ground, Officer Dukes unexpectedly and forcefully stomped on Mr. Gillard's neck. The impact caused Mr. Gillard's head to forcefully strike the pavement, resulting in a bruised forehead. Subsequent investigations revealed that Mr. Gillard's delay in complying was due to the presence of metal rods and pins in his leg and hip as a result of a previous injury. Following the aggressive act, Officer Dukes promptly restrained Mr. Gillard by placing him in handcuffs. Immediately afterward, Officer Dukes informed a second officer at the scene that there should be a gun behind Mr. Gillard, suggesting that Mr. Gillard had allegedly left a firearm behind the white SUV where he had been positioned prior to the confrontation.
There's a gun behind me. There's a gun, I believe, behind me.
I ain't got no gun there.
Mr. Gillard assured Officer Dukes that there was no gun present, and upon a quick examination, the second officer confirmed the absence of any firearm. Officer Dukes proceeded to conduct a search of Mr. Gillard's person, accusing him of failing to comply with orders. However, as evident in the earlier body camera footage, Mr. Gillard had been complying with Officer Dukes' commands from the beginning. Not once did Mr. Gillard exhibit any behavior that could be perceived as a threat, thereby negating Officer Dukes' justification for excusing excessive force against him. Once Officer Dukes ensured that Mr. Gillard did not possess a firearm, he decided to search the vicinity of the SUV himself in hopes of locating the alleged weapon. It swiftly became apparent that there was no gun to be found. Instead, it was discovered that Mr. Gillard had been carrying a stick wrapped in shiny silver tape, which he typically used as protection against aggressive stray dogs. Officer Dukes and the second officer helped Mr. Gillard back up onto his feet, at which point he began expressing his dissatisfaction regarding the unnecessary impact of his head on the concrete. The visible injury to Mr. Gillard's forehead, marked by a bruise and swelling, further supported his claim. In response to Mr. Gillard's confrontation regarding the incident, Officer Dukes provided a reply. At this point, it became apparent that Mr. Gillard was in need of medical attention. However, neither of the officers present on the scene initially took this into consideration. Fortunately, Officer Queenie Polidor arrived and promptly recognized the necessity for emergency medical services, requesting EMS assistance. As Mr. Gillard continued to express his grievances regarding the incident, Officer Dukes approached Officer Polidor and another responding officer to inform them about the situation. However, Officer Dukes' account was far from truthful. He claimed that when Mr. Gillard walked in front of the SUV, he believed Mr. Gillard was carrying a gun and repeatedly instructed him to drop it. Officer Dukes made further allegations claiming Mr. Gillard had his hands in his pockets and repeatedly ignored requests to show his hands. However, the body camera footage once again contradicted Officer Dukes' statements.
He was in front of the car when I came up, and he was walking like this. And I thought it was a gun at first. I said, drop the gun, drop the gun, drop the gun, drop the gun. I had him at gunpoint.
Clearly showing Mr. Gillard complying with the orders by keeping his hands raised above his head. Officer Dukes mentioned to a fellow officer that he wanted to take the stick as evidence, stating that it was the reason for his actions. In response, the fellow officer promptly questioned the necessity of using the stick as evidence, pointing out that the body camera footage would suffice. EMS arrived at the scene to attend to Mr. Gillard's condition. While Mr. Gillard was being examined, Mr. Julian approached Officer Dukes and requested a card with his details on it. In response, Officer Dukes promptly informed Mr. Julian that he did not possess a card and clarified that the department did not issue such cards in any case. Officer Polidor quickly recognized Officer Dukes' misstatement and promptly corrected him. She asserted that they indeed possessed cards and proceeded to provide Mr. Julian with her own cards as requested. On July 31, 2022, the South Carolina Law Enforcement Division announced that Officer Dukes was taken into custody and charged with first-degree assault and battery. Several months later, in November 2021, Mr. Gillard received a compensation settlement of $650,000 from Orangeburg, South Carolina. City officials additionally expressed their commitment to establishing a citizens task force to provide oversight and guidance regarding interactions between residents and the Orangeburg police.